In any case, there was a case that happened a little while ago that some of you heard of called Citizens United. There's, I guess, FEC, right? Federal Election Committee. And it came out and it caused a stir, as many of you know. And I was looking around for some writings on it that were not just the normal, it stinks kind of writing. And I came across an article called The Historical Roots of Citizens United versus the FEC, How Anarchists and Academics Accidentally Created Corporate Speech Rights. At the same time, I was teaching a course on anarchism here at Bard, and I was getting ready to give a lecture on Citizen United and censorship in Berlin, at State of the World Week. And so I read this article, and it really was, every once in a while you come across an article in the academic world that is not mind-numbing. And this one was not just mind-numbing, it was really good. And since that time, it's been a goal of mine to bring Zephyr Teachout here to Bard to speak to us about this really good, thoughtful, wide-ranging approach to campaign finance reform and to Citizens United. Some of you know that Zephyr Teachout was one of the driving forces behind the really innovative internet campaign of Howard Dean's campaign in 2004. She's now a professor, associate professor at Fordham Law School. And it is my distinct pleasure to welcome you here to Bard. Thank you very much.
Thank you so much. It was such a pleasure to come here. I took the train up, which is beautiful. I got to meet Roger, which is very exciting. And it is especially exciting to speak at the Arendt Center, which I just mispronounced for the last time. Roger has explained it as the Arendt Center?
Arendt.
Arendt.
Yeah.
Sort of like, isn't? Is that? No, aren't.
Aren't, yeah.
And my goal on this Constitution Day is to convince you that the First Amendment is a terrible thing. Not quite, but something along those lines. That at very different times in U.S. constitutional history, different clauses of the Constitution have become axes wielded by those in power. The Contracts Clause, the Due Process Clause, and right now I see the First Amendment as playing a similar and dangerous role, and especially dangerous because I made a few of you laugh and I said I wanted to convince you we're going to get rid of the First Amendment because there's a taboo around the First Amendment. There's a sense that of all the amendments, this is one that we all agree on. If I say, I take a cautious view of the Sixth Amendment, you might not kick me out of your dinner party. Or I take a conservative attitude towards the Fourth Amendment. Same thing. But if I say, I take a conservative attitude, I think we might have gone a little bit far on free speech. That sort of grounds to not introduce me to your mother. You know, this is sort of a... And wherever there are taboos, that's where interesting things tend to be happening in political society, I think. So, here's what I'm going to do. I am going to tell you a story. And then I am going to talk about the First Amendment and the rise of the First Amendment and talk about why it troubles me. And then, if we have time, talk a little bit about an example of an area where we might think differently about what I think is a very important policy question if we didn't have this tyrannical First Amendment. Just so you don't shut me out entirely, I do think the First Amendment is a good thing. I just think its current role is a little overblown. So here's the story. It's 1871, and old man has lent to the U.S. government $15,000 in 1871 dollars, which is, upwards of over $100,000 in contemporary money. He lives in Virginia. He's sick, and he wants his money back. He's written a letter. Nothing's coming. So he hires a lawyer. And he says, "Dear Mr. Childs, will you please go to Washington, D.C. and speak to members of Congress and get my money back?" And the lawyer says, sure. He signed a contract, he goes to Washington, he talks to members of Congress, he writes letters, he meets staffers, he gets the money back. Oh, you want me to stand in one place? I'm not going to sneak out. And he gets the money back. He dies, and his son then sues on the contract, says, you promised to pay me if I got your $100,000 back. And the old man, sick man, says, I'd prefer not to. That's a Bartleby joke, for those of you. I prefer not to. And the guy says, what are you talking about? You owe me this money. And he says, no. You're a lobbyist, and I don't have to pay you. And the case goes all the way up to the Supreme Court. This is the lawyer, son of the lawyer, says, this is like we made a contract for a car, and you said, I just don't want to pay for the car now that I've gotten the car. And the old man says, no, this is like we made a contract for prostitution. And you cannot go to the cops after we've made a contract for prostitution and get them to enforce that contract, because lobbying is like prostitution. It is so corrupt that there's no way courts are going to enforce it. So, it goes up to the Supreme Court. The lawyer argues, look, he had a right, constitutional right, to personally petition Congress. Therefore, if he had that personal right to go to Congress, he certainly had the right to hire somebody, to pay him to go to Congress, to speak for him. And the Supreme Court says, no, we are not going to enforce this contract. While an individual can petition Congress on his own behalf, they cannot pay a third party to do so. The foundation of the ruling was the idea that paid political petitioning, and in particular, named as lobbying, was against the public policy of the United States. The practice of paying someone else to make your political arguments would undermine the moral fabric of the country, of civic society. It would lead to distorted power arrangements. Citizens' virtue, according to this court, is the foundation of a republic. And if you make that up if you put that up for sale, you are undermining that foundation. Citizens are at once sovereigns and subjects. Citizens have a duty to be truthful in their interaction with public officials. They may not be truthful, but we as a court are not going to enforce a contract where somebody is speaking for somebody else's political, voice. And moreover, if an individual is allowed to lobby, what would happen, says the court, if we allow corporations to lobby? This is a direct quote. If any of the great corporations of the country were allowed to hire adventurers to make market of themselves, to procure the passage of a general law with a view to their promotion of a private interest, the moral sense of every right-minded man would instinctively denounce the employer and employed as steeped in corruption and the employment as infamous. In other words, everybody knows that corporations hiring lobbyists is corrupt and against the public policy of the United States. The court in this sees its role as limiting the temptation of private citizens. It says, in this case, there's no evidence that anybody bribed anyone. But if you put people in these kinds of situations where you can pay them to get legislation passed, you're going to start seeing bribery happen, even if we don't get to see the particular instances. And so we're not even going to allow what they call the inchoate step. We're not going to allow people to put themselves in that situation. So there are a few things that are remarkable and interesting about this case. The first is that there was nothing remarkable about it at the time. So if you went to any state court in the country and asked what was the result going to be in this case, they would have said, they're not going to enforce the contract. This was, Child's lawyer was going out on a limb trying to enforce this contract. Every state every state that I've looked at has similar cases where courts have refused to enforce corrupt contracts. And Georgia had, in its 1877 Constitution, criminalized lobbying as part of the Constitution. That was only recently taken out. It was criminal, although different variation, in California and several other states. The second remarkable thing about this case is that nobody mentions the First Amendment. It's not there. It's not that Child's lawyer mentions it and he loses. He mentions similar kinds of concerns. Well, you have a right to petition Congress, but he doesn't mention free speech. The idea of free expression is never once in the opinion or in any of the related opinions. So this case is now unimaginable. Right now, if you take any case involving politics, the first thing that the court is going to go to is speech. That has become the lens through which we do our political philosophy. And I gave you the examples of the quote talking about the citizen's virtue as a different kind of way a court can do political philosophy. You're always engaged in political philosophy when you're engaging in questions of politics and the court examining what's happening in the states. The question is, how do you do that? What do you think is the tool? Where we are now, to briefly review, in the last 10 years, the court basically uses the First Amendment to do all kinds of things, not just political philosophy. In 1911, Montana passed, in response to a mining company owning 90% of the press and a lot of the public officials in the state, Montana passed a law forbidding corporations from independently spending money around elections. The Supreme Court struck it down without discussion this year, using the First Amendment. In 1947, Congress passed a law banning corporate expenditures in campaigns. That's the core of the law that was struck down in Citizens United. And I'll return to that with the First Amendment as the tool that was used to cut down that law. But it's not just in that kind of politics. In 1999, Massachusetts had a regulation. They were concerned about kids smoking. So they passed a regulation saying you cannot have smokeless tobacco below 5 feet. Let's see. Below 5 feet. You can sell smokeless tobacco above 5 feet, but not below 5 feet. And you can't sell smokeless tobacco within 1,000 feet of schoolyards. Struck down because of the First Amendment. In 2005, California passed a law forbidding companies from selling minors games that include killing, maiming, dismembering, or sexually assaulting a human being. Last year, this California law struck down by the First Amendment. 2006, these are all tricky cases, but this one is particularly fun. 2006, Congress passed a law that made it a crime for people to falsely claim that they had won a Medal of Honor. This past year, the Supreme Court says we can't say that there's no political value in a lie. So, struck down because of the First Amendment. So, I'm not saying these are easy cases, but what you see is that across the board, the First Amendment has become the way that the court is managing a huge array of decisions that are made by localities, difficult decisions. How did this happen? Very briefly, this First Amendment was basically invented by justices that I have a lot of respect for, Brandeis, Holmes. There was a series of cases in the teens, 20s, involving anarchists. And those who were concerned about the militarization of America and had different political views than the mainstream. And in those series of cases, the anarchists lost. So 1917, Emma Goldman, who you hopefully know, a writer and activist, was arrested and sentenced to 2 years in prison for making speeches and distributing newspapers, encouraging people not to register for the draft. Her lawyers objected to the sentence. Well, it's 1917. They've read Trist. They know what role the First Amendment plays, free speech plays in our constitutional history at that point. They do not raise a free speech defense to the charge. They do raise a First Amendment defense to the charge, claiming that it was in violation of her free exercise of religion, because the different people could refuse to join the draft for religious reasons as opposed to non-religious reasons. And the Supreme Court says, we aren't even going to listen to that argument. We aren't even going to talk about that argument that there's a sentence, because it's so obviously wrong. So first anarchist attempts, totally shut down. And then there's this similar dismissiveness for the next several years. The court upholds sentences of up to 20 years for anarchists who are distributing leaflets. 5-year sentences, I mean, these are serious. They're serious now, but at the time, these are really substantial penal sentences. 20-year sentences, 5-year sentences for publishing German language newspapers. Communist Party leader was, her conviction was upheld for an effort to create a revolutionary working class movement. Hardly something that one would think of as dangerous in today's society. So the majority of the court is going along with these convictions. But Justice Brandeis and then Justice Brandeis and Holmes start dissenting. And they have these really beautiful dissents in which they're talking about the importance of free speech and how essential free speech is to the working of a democracy. In this, they are basically inventing a new idea for the role that free expression should play in a democracy. What you see is gradually, because they're both wonderful writers, these dissents start to appear in opinions, and even in majority opinions where convictions are upheld, there's a new recognition that they're not going to dismiss it like they did the Emma Goldman case. They're really going to take seriously this First Amendment idea and the idea of free expression. Finally, you see in 1941, not only are the free speech cases starting to win, but you start to see something else happen, which is that the justices are not just talking about free speech as an important principle for a democracy, but as the most important principle, first, of the Bill of Rights. So you remember there's a Constitution and the Bill of Rights. The first step is to say the most important Bill of Rights. The Bill of Rights is the First Amendment. And you see that in the 1941 case. And then the next step is you see a movement from the most important part of the Bill of Rights to the most important part of the Constitution. The left, there's an interesting interplay here in the 30s and 40s and 50s between the left and the right. The right started off pretty resistant to this free speech notion, and the left said, no, we got the ideas. The right's trying to shut down ideas. We got the ideas. If we can just get these ideas out there, we're going to win the war of ideas. I don't even like using that expression. It shows how socialized I've become. But we're going to win this battle if we can just take the top off and get rid of these censorship laws and other laws. Throughout the 30s and 40s, basically, the right is resistant. And then you start seeing a change in the 50s and 60s. Brandenburg versus Ohio is sometimes called the coronation of the First Amendment. So in Brandenburg versus Ohio, a Nazi leader was in Ohio, Klan leader. In Ohio, got a rally filmed showing men in robes and hoods, burning a cross, making speeches. One of the speakers talked about the possibility of revengeance against the Jews and the niggers. And it announced plans for a march on Washington. He was charged with advocating violence. This is a 1969 case. A unanimous Supreme Court overturned that conviction without discussion. It's not actually an example of a case where you see a lot of the elevation of the First Amendment, but it shows where the court had gotten to by '69. And one of the things is the right started buying into the First Amendment. This is now a unanimous decision. And it's in the late 60s and early 70s where you also see, and they have a bunch of new ideas. There's a lot of, look, maybe the left's really wrong. Look what's happening in the Soviet Union. We have the new ideas. There's some problems with the old left. We're going to open up. We can win this battle-place of ideas. And then there's also the development of corporate interest in speech rights and an understanding in the late 60s, early 70s that possibly this is a way that corporations can use to expand their own power relative to the state. So just to give you a few examples of what happens after '69, the scholars across the political spectrum really get on board with this idea of the free speech constitution. I'm going to give a few examples of what they've said. Free speech is the paradigmatic liberty through which one participates in a democracy. Its constitutional instantiation, you know, it's a scholar because they're using the word instantiation. Its constitutional instantiation, the First Amendment becomes identified with democratic pluralism itself. So here's a logical line. Free speech is democracy. Owen Fisk, who's a wonderful First Amendment scholar, says there's a sense that the First Amendment is not a technical legal rule, but rather an organizing principle of society central to our self-understanding. It has a special place or exception reserved for speech. Now this, of course, then has an effect on popular opinion as well. I don't know if this resonates with you guys, but their First Amendment Center, which has its own interest, gets people to rank amendments, sort of a fun game. And Americans routinely identify free speech as the purpose of the First Amendment. They sort of know what this is, they know what the First Amendment is, 4 to 6 times more than they know what any other amendment is. So everything else has sort of become secondary in the popular imagination as well. What this means, as I've suggested before, is that all these debates happen through this lens. I have a friend who is arguing a Supreme Court case next month on government spying. I suspect that what you'll see is that in a government spying case, that the bulk of the arguments are going to be about the First Amendment. Now, you may or may not remember the Fourth Amendment, which protects people against unreasonable search and seizures. But the strategic thing to do in these cases is go to the court with the first... you're looking puzzled. Go to the... Okay. I know I'm talking to a non-law audience, so I want to make sure I make sense on this, and you can ask questions. But there's a Fourth Amendment that says that you're protected against unreasonable search and seizures. There's a First Amendment that says you have free expression. The government's spying on you. Which clause of the Constitution would you think would be the clause you might use? You might say, I don't think there should be unreasonable search and seizures, including government spying on me. But the First Amendment has become so central to what the consensus is on the court that it probably is going to make more strategic sense to focus on the First Amendment and say it violates their expression rights to have the government spy on you, than to use the Fourth Amendment as it violates your Fourth Amendment rights to be spied upon. In the voting area where I work, there's an effort to show that voting is a First Amendment right. Because if you can show that voting is a First Amendment right, then maybe you have a better chance of winning the voter ID cases. So just across the board, whatever you have, if you can shoehole that into the First Amendment, maybe you have a better chance than if you use some other part of the Constitution. For the most part, the left has accepted this, and the right has embraced it with glee. The left has accepted it, and what that means is that the debates about other values that you might have, like equality, are had through the avenue of the First Amendment. Or if you're interested in civic participation, you'll try to shoehorn that and say, well, the right has the wrong understanding of the First Amendment. They should have this different understanding of the First Amendment. The First Amendment really means that everybody needs an equal voice. And so that there's a left-wing discussion of equal voice, but it's had through what I think is a pretty cramped lens. So, what's wrong with this? I mean, the cases that I read to you, I'm terribly sympathetic to. Whenever I mention the First Amendment, that happens. I'm horrified that political pamphleteering is criminalized. I'm thrilled that Brandeis had these dissents. I absolutely want to defend the right of Brandenburg to make his speeches. But what's happened, I think, is that it's gotten disproportionate. The most obvious effect is what's happened in the political speech area. So in Buckley versus Vallejo, which is one of the weirdest opinions. It was a per curiam opinion, which also means that everybody joined. You don't get independent voices on it. It was written really quickly. It sort of lacks internal consistency, and nobody likes it. People on the left don't like it, people on the right don't like it, but it has become the foundation of how we deal with political cases. It's the case that in 1976 reviewed a whole series of campaign finance laws from the post-Watergate era and said some of these are going to be allowed, some of these aren't going to be allowed. Without getting into the weeds, there's a few important things it did. It said that money is speech. So here you see an example of very creative lawyers saying, well, if we can convince people that spending money is a form of political speech, then it gets protected. And ever since then, money is speech in the political realm. It opposed speech rights to the anti-corruption interest or other interests in civic society. So they're seen as opposite to each other, which isn't very good for our anti-corruption interest over here. If you think of other kinds of interests, the kinds of interest I talked about, the court talking about interest versus child. As a separate matter, it talks about bribery laws as separate from campaign finance laws. That's a pet peeve of mine. Campaign finance laws are anti-bribery laws. So when the court strikes down campaign finance laws, they're saying states cannot pass bribery laws. All bribery laws are really, really hard to enforce. You always need right-line rules to make them enforceable. That's another talk for another day. Anyway, for the next 26 years, the debate is framed by Buckley, and framed with this sort of growing consensus around the First Amendment and the First Amendment as the heart of the Constitution. So, I want to compete. In Citizens United, Kennedy sort of dresses up the First Amendment as this wise elder. He talks about the ancient principles of free speech. And says we have to give the benefit of any doubt to protecting free speech concerns. So basically what he's saying and admitting to is once free speech is mentioned, I'm going to put my blinders on. It's no longer going to be a balancing of all kinds of different concerns. Free speech is the trump card. And within it, I mean, one of the things that I think is disturbing is there's little alternate political theory to balance it. So it doesn't talk too much about like what politics is about, what politics is for, what political life is like. Instead, it talks very abstractly about speech. So, what's wrong with this free speech era that we're in? The first, I think, of course, is what we've seen with super PACs, and we have yet to see what's going to happen there. This is the amateur hour this year on super PACs.